Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utility Subcommittee. Today is Tuesday, March the 5th, 2024. I'd like to call this meeting to order. Mr. Clerk, can you take the roll, please?
Representatives Alexander, Burkhart, Clemens, Freeman, Hale, Holsclaw, Johnson, Marsh, Thompson, Vaughn, Vital, Zachary. Chairman,
Here.
you have a quorum.
Thank you, Mr. Clerk. Members, before we get started today, do we have any personal orders? If not, we do have a few housekeeping things at the request of the sponsor. Item number 2, that's House Bill 1842, has been rolled 1 week. At the request of the sponsor, item number 6, that's House Bill 1811, has been rolled 1 week. And at the request of the sponsor, item number 7, that's House Bill 2173, has been rolled 1 week. Members, that brings us to the calendar, and we actually are going to go a little bit out of order. We're going to take up item number 4. Representative Antonio Parkinson came and asked me to do a special request. He's got somewhere to be. So we're on item number 4. That's House Bill 2781. We have a motion. We have a second. And I've got some amendments, Representative Parkinson.
Yes, sir, Mr. Chair. The amendment we're going to go with is 013767.
That's the only one we're putting on?
Sir.
Okay. Members, we're voting on amendment 13767. Can I get a motion and a second? We have a motion. We have a second. Do you want to explain that or go ahead and put it on the bill?
It's going to rewrite the bill.
Okay.
So
Members, we're going to vote to put that amendment 13767 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended and you are recognized on your bill.
If you don't mind, Mr. Chair, just 1 second, please.
Okay.
Mr. Chair, I think I put the wrong amendment on there. And the amendment that we're looking for is 014816. You got that?
Okay. Members, we're going to reconsider our actions on that previous amendment that we put on there. That's 13767. Okay, so we're going to move to withdrawal without objection. That amendment is withdrawn, and now we're putting amendment drafting code 14816. Is that what you're showing?
That is it. Yes, sir.
Okay, we have a motion. We have a second. All in favor say aye. All opposed say no. The ayes have it. The bill is amended. Representative, you're recognized for explanation.
Thank you, Mr. Chair. Let me thank Commerce and Insurance for the good catch there, because I was about to jack that up. Mr. Chair, this is the cosmetology compact bill that was actually brought to us by CSG. The compact creates a multi-state license for cosmetologists to make it easier for individuals to practice in other states. The compact, I'm sorry, my notes are getting mixed up here. Okay, the compact does not impact someone's ability to have a Tennessee-specific license. In addition to the cosmetology licensure compact, this amendment does 3 things to decrease regulatory burdens in the cosmetology and barbering industry. 1, it removes inconsistent educational requirements for cosmetology and barbering students. Number 2, it removes continuous consecutive requirement years of experience as cosmetologists, barber practitioners for them to become an instructor. And number 3, it removes mandatory penalty fees for master barbers to reinstate expired licenses to align with the cosmetology statute that we've already passed. That's what the bill does.
Sponsor, we appreciate that explanation. Members, do we have any questions for the sponsor? Chairman Vaughn, you're recognized.
Thank you, Mr. Chairman, and to my dear friend from Shelby County. You being the master of barber and cosmetology legislation, when these folks go to get this new compact, I guess it'll be a compact license in and of itself that qualifies them in a multi-state area.
Yes, sir.
You're comfortable because you are the dean of legislation when it comes to people's appearance and their hygiene with regards to the tops of their heads. I just want to make sure that you're good with all this, and how are we going to make sure that the compact's licensure requirements and curriculum meets your standards, sir?
Thank you for that.
You're
Mr.
recognized,
Thank you
sponsor.
for that, Mr. Chair. And I do have full faith in the bill. And this also puts us in the rulemaking space with the other states as the rules are being made for this compact license also.
Chairman Vaughn?
Thank you, Mr. Chairman. So if we get in on the ground floor, we're going to be able to square things away as we see fit from the beginning.
I think so.
Sponsor?
All right.
Yes, sir.
Thank you, sir.
Thank you,
Appreciate
sir.
that.
Yes, sir.
Members, do we have any other questions for the sponsor? All right, members, we're voting to send House Bill 2781 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Congratulations, sir. Your bill is on its way to full commerce.
Thank you, Mr. Chair. Thank you, committee. And Mr. Chairman, thank you for the grace. Truly appreciate it.
Next up is item number 1. That's House Bill 2178 by Chairman White. And Chairman White, I'm showing an amendment that you've got.
Yeah, how about 014722?
That's what I'm showing. Members, we are voting to put Amendment 14722 on the bill. We have a motion. We have a second on the amendment. All in favor say aye. All opposed say no. The ayes have it. Sir, the bill is amended, and you are recognized on your bill for explanation.
Well, thank you, Chairman and committee. You know, over the years, I've been working on this particular one for several years, but over the years, you know, Tennessee does a very good job in funding degree programs such as we have Tennessee Promise, Tennessee Reconnect, Hope, and all those things. But currently, right now, a lot of our high demand workforce ready skills are credentialed programs. A credential is not a degree, but you can go and get a credential in 8 to 14 weeks in things like welding and cybersecurity and coding, and come out at that point and get a good job, which then puts you into the workforce and brings you in income. One of the major issues was, especially with some of our especially our lower economic workers, is that they can't hang on for a half year or a year or 2 years for community college or even a 4-year. So we have a lot of these in our state, but we've never been able to fund our credentials. And I'm also a big advocate on stackable credentials. You know, get one credential, then build upon another. So what this particular bill is asking for, it provides grants for a short-term workforce-ready credential. They usually last 18 to 14 weeks. In the program such as I mentioned, and other high demand fields. And so that for the first time, we'll be reaching out to these to get people into the workforce in things that are very, very needed in high demand fields. And with that, I do renew my motion, and I do have the director of Tech 901 out of Memphis. If you'd like to hear from him, he is here at the will of the committee.
Chairman, we appreciate that explanation. Members, do we have any questions, or does anybody want to hear testimony? Question has been called. Chairman White, I will say this sounds like a great bill. And they came to see me today, and I didn't realize that this was something that there was no money set aside for this, like there are at TCAT or anything like that. So this sounds like it's a pretty good bill. I hope this gets funded. So
Thank you.
I like it. So members, we're voting to send House Bill 2178 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Congratulations, Chairman. We'll see you in full commerce.
Thank you very much, committee.
Okay. Okay, members, we're going to roll item number 3 to the hill of the calendar. That's House Bill 2235. Next up, members, that brings us to item number 5, House Bill 1958 by Representative Powell. Chairman Zachary, you're recognized.
Thank you, Mr. Speaker. I move previous questions.
Previous questions be called. Members, we are voting on House Bill 1958. All in favor say aye. All opposed say no. No. Do I? Okay, so we have an objection. Chairman Clemens, you're recognized.
Sure, you had the answer. My question is, are we going to set the precedent of not allowing individuals to actually introduce their legislation before we vote on it, or to at least give us a summary of what we're voting on?
So the situation we find ourselves in is that the previous question has been called, and so you've objected to the previous question. So members, how many people object to that? I only hear one objection. So we have three objections. Okay, members, we are voting on a roll call vote on previous question. So, Mr. Clerk, if you take the roll, please.
Representative Alexander,
We are voting on previous questions. The aye is that we vote on previous question. No is that we hear debate.
Representative Alexander. Representative Burkhart. Representative Clemens,
No.
Representative Freeman. Representative Hale. Representative Johnson. Representative Marsh. Representative Thompson. Representative Vaughn. Representative Vital. Representative Zachary. Chairman.
Aye.
Chairman, you have 9 ayes, 3 nays.
Okay, members, we are voting on House Bill 1958. All in favor say aye. All opposed say no. No. Noes have it. The bill fails. To item number 8, that's House Bill 2025 by Chairman Clemens. Chairman Clemens, I don't see the amendments, so you are recognized on your bill. We have a motion. We have a second.
Thank you, Mr. Chairman. Give me a second here. I wasn't expecting that last bill to go so fast. So what this legislation seeks to do is to address some of the affordability issues with housing in the state of Tennessee. We have limited local government's ability to create affordable housing in some ways. So I tried to think of a creative way to reduce some of the costs for individuals looking for housing. And some of that was to address the transparency issues, to make sure individuals know what they're going to be required to pay if they're able actually to get into a housing. So if they sign a lease, they need to know up front if that lease is going to include the rent plus a bunch of other fees. So what this would require landlords or management companies to do is to disclose the total amount an individual would be required to pay in a month. It would create the opportunity for landlords or management companies to accept a standardized form so that, what a lot of people pay these application fees, which this addresses as well. Those application fees are used to pay for criminal background checks and rental history and things like that. But there's the opportunity out there to create a standardized form, which allows individuals to have all that so they can use it at different places to which they're applying to live. And that would save them money. It gives the landlords, it doesn't require landlords or management companies to accept them. It gives them the opportunity to accept them and requires them to disclose whether or not they accept them on the front end. And then, of course, it would cap some of those application fees to the actual cost required to do those background checks. And that's about it, Mr. Chairman. I'm happy to answer any questions. If anybody has anything else on this legislation, I think, ultimately all I'm trying to do here is not put any onerous restrictions on landlords or potential tenants. Or management companies or leasing companies. Just want to have transparency for people who are going to rent housing, eliminate any fees if necessary, but not tie the hands of these companies that are providing housing. So that's it. With that, I move passage.
Thank you, sponsor, for the explanation. Do we have any questions? Chairman Zachary, you're recognized.
Thank you, Mr. Chairman. Chairman Clemens, does this apply to individual renters or is this just to leasing companies? Individual landlords, I should say, not renters, individual landlords.
Yeah, so this would apply to landlords as well.
Chairman Zachary.
Thank you, Mr. Chairman. The challenge I have with this bill is that a notification bill is one thing, but this bill goes beyond that in terms of prohibiting fees they can require, even a fee for online rental payments, which unfortunately so many landlords right now are at razor thin margins trying to keep housing affordable. Many of them have to charge a fee for any kind of online payment. And so that's just one example. And so I just think this is almost a price control or an attempt to limit the ability of individual landlords to be able to provide effective service to the people in our community, the people who need it. And so for those reasons, I can't support the bill. Thank you, Mr. Chairman.
Chairman Clemens, you recognize.
Yeah, thank you. And so what we're doing here is we're just trying to prevent what is referred to often as junk fees. So if the landlord is not actually incurring any cost in that, so we don't want, them making up fees to charge tenants. But for all actual costs that they incur, they're allowed to do it. They just have to disclose it up front. That's it. So if they're renting to someone and says, this is one of the fees that we charge every month, and this will be added to your lease payment or what your base rent is, then they just need to tell individuals that. That's it. We're not trying to tie their hands or prevent them in any way. It's just that disclosure up front. And whether it's a landlord or a leasing company, the tenant's a tenant. Thank you.
Chairman Zachary.
Thank you. And then just to follow up, and maybe I'm reading this incorrectly, but says the legislation prohibits a residential rental company, landlord, leasing company from charging the following fees. And then it goes into a list of fees. And so if those are directly prohibited, then it says nothing about a disclosure. It says those fees are actually prohibited. Thank you, Mr. Chairman.
Chairman Vaughn, you recognized.
Yes, sir. And I was going to point out, I appreciate your efforts to reduce the cost of housing. There's several different avenues people can take, and this is the one that you've decided to take. I want to kind of fight regulatory inflation myself. But on this one, the two things that I specifically that have thrown me from being able to vote for this is the fact that you've got a non-refundable application fee that exceeds $50 or an application fee that exceeds the actual costs incurred by the landlord in processing the application. That gets really difficult to calculate over whose costs are what. And so when you limit it to $50 and you have to demonstrate that you've had costs that go above that, if you want to go for $100, I know that probably leasing an apartment in Bolivar, my hometown, is less expensive than leasing an apartment in Collierville where I live now. And so having to keep that up is an issue for me. And then the last thing is that private right of action at the end. I know that attorneys have different feelings about those things than the rest of us do, but placing this into a court of competent jurisdiction for violations of the bill is another thing that I just think sets up the ability to drag folks into court over these issues that are a little murky at best. And so that's why I'm not going to be able to support it today. But I do appreciate the effort, and there's a lot of things in here that I frankly kind of agree with. But those things just make it to where I can't vote for this legislation. Thanks.
Chairman Clemens, you got anything?
Yeah, thank you, Mr. Chairman. And I appreciate those concerns. And I assume, I know that individuals who own a lot of properties in the various counties and stuff, and I assume those application fees aren't flat fees. And I assume if you're renting property in, say, Carroll County or versus Shelby County, your cost might be different. And I would assume, I would hope landlords would have a base amount. They know what their costs are for individuals in those, or if they use the same service, they may use one service that handles it all for them. And so I would think that they would know what that cost is. And that's the reason I put the or language. So I don't want to limit landlords to that $50 application fee. I gave them the option of that actual cost incurred by them for whether the service they're using to process the applications or what have you. And I also have in here that if a management company owns more than one residential unit or more than one complex, and while people are searching for housing and places like my county that I have the pleasure of representing, paying the same management company multiple application fees when the same company's running the same background checks, trying to limit that to one if they own multiple units, or multiple properties, there's a fairness issue. And so I tried to protect the rights of the property owners in here by creating that or language. And then with regards to the civil action, that's one of those things where, if we're going to pass a law and we're going to have some protections in place, I think there needs to be some teeth to it. So it's not to, make this state over litigious or anything like that. It's just simply to say, this is a law, stick to it, or there's repercussions.
Chairman Vaughn.
Thank you, sir. It's one of those cases to where I'm probably there with you on about 70% of what's in here. It's that other 30 that's giving me heartburn, but I appreciate you bringing the bill.
Chairman Clemens, I have a question. Where did this bill come from? What brought this forward?
I wrote it.
I mean, did somebody ask you to do this, or was it just?
No, it really, I've spent the last several years, I passed two, along with Senator Yarborough, we passed two of the last, I think, fairly described as substantive affordable housing bills, and that was back in 2015. And since that time, I think this state legislature has limited local governments in some ways from addressing affordable housing, like here in Davidson County. And so I've been trying to think of a backdoor way to approach this issue to limit cost in any way. And I realize application fee costs are not, extraordinary, but some of these things, people do get hit with some of these hidden fees. So I did some research and thought this might be a good way to save people a little bit of money who are looking for housing.
I noticed you've got I was looking here, you've got the late fee limited to 10%, and then you've got a unique way of having it positioned where if it fell on a Sunday or a legal holiday, that couldn't count toward the days. Is that, I thought that was kind of creative.
Well, that's general. I mean, that's in pretty much in every deadline you have, and in rental law. I mean, with regard to leasing, you generally, even with regards to court actions, if you have a deadline, that doesn't count against you. I mean, the courts are going to be closed, or offices are going to be closed, people are on vacation, so there's no reason for that to count against either party. That's pretty common.
Members, do we have any other questions for the sponsor? Chairman Zachary, recognized.
Thank you, Mr. Chairman. Question on the bill.
Question has been called. Members, we are voting on House Bill 2025 to send it to full commerce. All in favor say aye. All opposed
Aye.
say no. Noes have it, the bill fails. Members, that brings us to item number 9. That's House Bill 1814 by Representative Thompson.
1814.
Do we have a motion? Or a second? We do have a motion. We do have a second. All right, Representative Thompson, right now it looks like you do have an amendment on that. What drafting code are you showing?
I should have it out. Let's see, it is 14574.
That's what I'm showing. Do we have a motion and a second on the amendment? It looks like you've got the same motion and a second on the amendment, so you were recognized on your amendment, or does that rewrite the bill?
That does rewrite the bill.
Okay, let's go ahead and put it on the bill. Members, we're voting to put amendment 14574 on the bill. All in favor say aye.
Aye.
All opposed say no. Ayes have it. Sir, your bill is amended and you're recognized on your bill.
Thank you, Mr. Chairman and committee. HB 1814 makes some small changes to the Landlord-Tenant Act. And I've worked pretty closely with the Tennessee Apartment Association and the Tennessee Realtors to make sure it doesn't interfere with some of their members' business models. And both these organizations are neutral in the bill after the amendments added. Current law requires a landlord or an agent to furnish the contact name and address to the tenant in a rental agreement. This bill changes that to say that a lease should either have a portal system to allow tenants to contact the landlord or agent for needed services on a 24-hour basis. This is primarily the larger apartment management companies and other leasing companies. Now, if the landlord does not have such a system, the lease should include, in addition to name and address, either a phone number or email address for both office and maintenance contacts. The reason for the bill is to help ensure that tenants have access to the necessary contact information to request services that are required under the Landlord-Tenant Act. While this won't affect the vast majority of landlords or property managers, we found an increasing number of tenants who are unable to find the appropriate contact for services. And this is more common in the last few years due to out-of-state investors who have bought properties, convert them to rental, but sometimes fail to provide service or any valid means of contact to their tenants. So the bill won't solve all those problems, but it will help across the state. And I'm happy to take any questions.
Thank you for that explanation, sponsor. Members, do we have any questions for the sponsor? If not, we are voting on House Bill. Chairman Vaughn, you recognize.
Yes, Representative, this time I'm only hearing agent and management company, not ownership. Am I mishearing? Is it still in there? I know that I had numerous constituents that were concerned about the fact that this may wind up to where they were having to give their home address out to people that for properties they don't even manage, that they have hired that service out. So I'm just trying to figure out where we are on this one. It sounds different than it did last time.
Sponsor recognized.
Thank you, Mr. Chairman. Yeah, it does include owner, and that is in the
Sponsor,
bill.
talking to the microphone, please.
Oh, excuse me. It does include owner, and that is in the bill. There is no requirement to provide your personal address. In fact, Chairman Zachary had that complaint a year ago with a similar bill, and I wanted to make sure that it was not in there this time.
Chairman Vaughn.
Thank you, sir. Well, that's a huge red flag on this bill. Well, that's a bad term to use. That's a huge problem for me on this bill because my amateur Googling skills, I can find out a lot about a lot of folks on this. And so when people think that that's a service that's being provided, and maybe that's the quickest way to get rid of a landlord, I don't know, but that's the issue. I mean, a property manager. But I'm just struggling with getting there on this bill. If we're going to be disclosing ownership information whenever they've signed a lease and it details who their relationship is with. So for that reason, I can't support you on this one.
Sponsor.
I'm just wondering, perhaps we haven't communicated, maybe it's my fault, about communicating this, the actual intent of this bill. All we're doing is asking for contact information for a tenant. We're not asking for any personal information. We're not really approaching the quality of service of either an owner or a property manager or anyone else or a landlord. We're just trying to make sure that a tenant will have the ability to contact the right person when there's a major problem with their apartment or their rental unit.
Yeah, sponsor, keep going.
If it would be appropriate, I'm happy to roll it a week to maybe make sure that members are a bit more aware of what this actually does.
Chairman Zachary.
Thank you. Thank you, Mr. Chairman. Thank you, Representative. I think rolling it would be good because I do think I share the same concerns as Chairman Vaughn. I think if we can just clarify this related specific to management companies again, because what he's referencing, I have the same issue with numerous constituents who are individual landlords and the concern of divulging personal information, protecting themselves behind their LLC. Yeah, if you would roll it, and I think we're closer, and I think this conversation is productive. I appreciate Chairman Vaughn's comments, but yeah, Mr. Chairman, I'm going to make a motion that we roll this a week.
That's a proper motion. And Representative Thompson, I know you've worked hard on this, and so it sounds like you're almost there. So I think it's a good idea rolling a week. So without objection, we're rolling House Bill 1814 to rolling it 1 week. Members, that brings us back to item number 3. That's House Bill 2235 by Representative Hicks. We have a motion. We have a second. Representative Hicks, I do not show any amendments on your bill, so you are recognized for explanation.
Thank you, Mr. Chairman and esteemed committee. It's good to be here. This bill was brought to me by the Tennessee Association of Professional Surveyors. It aims to clear up confusion that they are currently seeing when surveyors are striving to obtain license. This bill does a handful of things. Currently, there are 5 pathways to becoming a licensed surveyor. This bill clarifies that under each pathway, the years of practical experience needed must be under the direct supervision of a practicing licensed surveyor. It also clarifies that hours someone obtains under the intern certification counts towards the total hours needed to become licensed. Right now, the Board of Examiners is seeing a lot of confusion amongst interns as to whether those hours count or not. Lastly, the bill makes a couple of changes for those who pursue a high school degree or GED pathway. It decreases the years of practical experience needed from 16 years to 10, but increases the hours of board-approved coursework needed from 12 hours to 18 hours. With these changes, the Tennessee Association of Professional Surveyors is hopeful that this will eliminate much current confusion, and there is a lot, in the license process and encourage more people to pursue the surveying profession. And with that, Mr. Chairman, I'll stand for any questions.
Thank you for that explanation, sponsor. And this sounds like a good bill. The surveyors came to see me, and it sounds like this is a profession that needs a few more folks getting involved in it. And they expressed same thing you did, that it seems like that the pathway for becoming a licensed certified surveyor needs to be tweaked a little bit. So I appreciate you carrying this legislation. Members, do we have any questions for the sponsor? If not, members, we are voting to send House Bill 2235 to full commerce. All in favor say aye. All opposed say no. The ayes have it. Congratulations, sir. See you in full commerce.
Thank
Members,
you, Mr. Chairman. Thank you.
that brings us to the end of our calendar. And so without objection, this meeting is adjourned.